All right, good afternoon. It is my distinct pleasure to welcome everyone to an event commemorating and celebrating the installation of my colleague, Sam Calhoun, as the Robert O. Bentley Professor of Law. And before I say a few words about Sam, I'd like to provide some information on Robert Bentley, in whose honor this endowed professorship was established. I'm actually going to read from an inscription on the W&L donor wall where we honor our most generous benefactors to the university. And the following is from a plaque recognizing the generosity of Elizabeth M. and Robert O. Bentley. After graduating from Washington & Lee School of Law in 1926, Robert Bentley practiced law in Newark, New Jersey until 1932 when he opened his own office in Hackensack. In 1956, he became associated with the firm of Plimpton and Bentley in that city. He served as a municipal magistrate for Pascagoula Valley, New Jersey from 1946 to 1967. Bentley, a native of Allentown, Pennsylvania, married Betty Myers in 1957. They moved to Lexington in 1970, just before retirement. Over the years, Mr. Bentley served Washington & Lee as a class agent and as a member of the legal fraternity Phi Delta Phi. Bentley died in 1989, survived by his wife, who at the time continued to reside in Lexington and took an abiding interest in the university. By the way, Mrs. Bentley passed away in 2012. She continued to reside here in Lexington, passed away in 2012 at the age of 97. Betty Bentley has made gifts to the university that have resulted in a named endowed professorship and an honor scholarship fund in both the School of Law and the undergraduate division. So that's just a little bit of background on Robert Bentley. Again, this scholarship was established in his honor by his wife. All right, now to our honoree, Sam Calhoun. In commemorating his installation to this endowed professorship, we recognize and celebrate a range of qualities that Sam has brought to our law school community over the course of his remarkable career. On a faculty known for the quality of its teaching, Sam has been a true standard bearer in terms of classroom instruction. He has regularly taught the first-year contracts course, which a couple years ago included a separately credited adjunct legal writing course that was appended to it. A wide range of alumni have cited that small section of contracts as one of the most enjoyable, engaging, and rewarding courses that they had during their law school career. Sam consistently receives glowing evaluations from our students in this staple first-year course, and it's only fitting that he's concluding his academic career by teaching that signature course at the law school one more time. Actually, we're fortunate to have a number of his students, former students in that class, and even current students in that one first-year course here with us this afternoon. Actually, when I came down here to try to get comfortable in the room before this ceremony, I thought I'd have plenty of time, and I walk around the corner, and I hear this bellowing voice coming from the room, and Sam was teaching that contracts class seemingly like 15 minutes ago. Right?
It's true.
A good warm-up for his talk. All right. In addition to being an anchor of our commercial law curriculum, and one of the few individuals in the building who could speak to a question on payment systems, it's supposed to be funny. And likely one of the only individuals who would do so enthusiastically. All right, Sam has been courageous in his other course offerings. And of course, the course I have in mind is the seminar that he has developed on the abortion controversy. Through this course, Sam has modeled the academic ideals of open inquiry and civil discourse by thoughtfully presenting a range of viewpoints on a deeply polarizing subject in a manner that was intended to foster engagement of all individuals that made up a part of that course, with that level of engagement producing a deeper level of understanding. With that approach in mind, the idea of engaging viewpoints of difference, Sam helped organize a fantastic law review symposium just a few years ago that examined the Roe versus Wade decision, one that featured nationwide experts that had positions and viewpoints that truly span the spectrum on that issue. On the research front, Sam has been remarkably consistent in his production of high-quality scholarship over the course of his career. His research has fallen into several camps, In one category, Sam is engaged in rich, scholarly debate over the proper role of religion in public discourse and in the shaping of public policy. In another camp, Sam has a litany of articles examining abortion and the legal regime that has developed around that issue. And most recently, Sam has devoted his scholarly energies to examining the constitutional concept of separation of church and state, something that we're going to hear, I think, a good bit about this afternoon. Lastly, Sam, I think, is a scholar of Abraham Lincoln, right? I don't know if I'm going too far to refer to Sam as a Lincoln enthusiast, but I think I'm on safe ground to say he's at least an admirer. And he has co-authored an article with our colleague in the politics department, Lucas Morel, that examined Abraham's religion. Beyond his teaching and research, Sam has been really a consummate institutional citizen for our law school and our university, contributing to the health and success of our law school in numerous ways over the years. Let me highlight just a few significant roles that Sam has undertaken recently. He served as the Associate Dean for Academic Affairs for a critical 3-year stint, 2013 to 2016, a period which I will note coincided with our accreditation review for the American Bar Association. By the way, I think any associate dean that successfully navigates an accreditation review is entitled to some form of combat pay. But Sam guided us through that process in extremely fine fashion. During that same, roughly that same period, Sam chaired the law school building committee that oversaw the significant renovations to Lewis Hall that occurred during the summers of 2014, 2015. I imagine Sam can still recite the number of new windows that we had installed.
55.
And one last item that I'd like to highlight is that Sam recently concluded a 3-year term as the class of 1960 Professor of Law and Ethics, a position through which he guided the programming for the Institute for Honor at the university. In this capacity, he served the university remarkably well in this capacity, organizing a range of phenomenal symposia during this period and bringing in some truly engaging speakers to our campus. The extent of Sam's contributions to the law school and to the university, however, cannot be captured by a mere recitation of all the positions that he has held over the years, and if I tried to do that, it would take far too long in any event. And while the following description may not be too colorful or flattering, in my mind, Sam has consistently provided what I will call a source of institutional glue for our law school. His common decency, compassion, sound judgment, and good humor all have contributed to our school being a better place. These qualities can fill in gaps in an institution. They generate lasting bonds, and they make our school stronger on the whole. So this afternoon, we honor Sam's remarkable abilities as a teacher, his impressive record of scholarly productivity, and the many ways he has fostered the aspirational vision that we have of our law school community. And we do this through his formal installation as the Robert O. Bentley Professor of Law. Please join me in congratulating Sam on this honor. Sam, congratulations.
Thank you. I appreciate it. Thank you very much. Thank you, Brent. Obviously, thank you for the great honor. I appreciate it, and for that generous introduction, and thank you all for coming. So I was thinking about this talk and how some of you might be a little nervous at attending a talk on law and religion, but I've had misgivings of a different sort. I was worried that a talk on law and religion might be boring in itself, so I decided to throw abortion into the mix. It's this tendency of mine that has always made me very welcome at big family gatherings or as a guest at dinner parties that my friends have held. Now, I hasten to say we're not going to stay on abortion for very long, but I think it's a good way to introduce this topic. This past May, Linda Greenhouse, of course, the famous columnist, wrote in the New York Times that the United States, and I'll quote her here, was reconfiguring itself into a theocracy that would have appalled the founding fathers. So what triggered this alarm in Linda Greenhouse? It was Alabama's recent enactment of a more restrictive abortion law, and particularly the statement of Alabama's Governor Kay Ivey. When she was signing the bill, she said this: "This legislation stands as a powerful testament to Alabamians' deeply held belief that every life is precious and that every life is a sacred gift from God." Well, Greenhouse reacted with alarm to this statement, and she talked about how religion's grip on public policy will hurl us backwards into a world we couldn't even imagine. And she proposes a remedy in this article, and that is to restore the First Amendment's Establishment Clause to our working civic vocabulary. And many of you, I'm sure, know that the First Amendment's Establishment Clause says this: "Congress shall make no law respecting an establishment of religion." Basically, Greenhouse believes that this Alabama law violates the Establishment Clause because of the way she characterizes the law. That is, it was based on religion and a religious viewpoint, therefore it violates the Establishment Clause. Similarly, recent presidential candidate, I guess she's withdrawn, New York Senator Kirsten Gillibrand, also blasted the Alabama law, saying that it violated the principle of separation of church and state. She agrees that every American has the right to believe whatever they want concerning religion, but that the Constitution prohibits imposing one's religious faith upon other people. So it was Gillibrand and Greenhouse, pretty close to each other, that again prompted my thinking about this topic. And of course, I don't agree with either one of them in terms of their view either of American history or of American constitutional law. And I hope that my lecture's title makes that clear. Neither American founding was intended to separate religion from politics. Many of you, though, may have been puzzled by that phrase, neither American founding. I mean, after all, there was just one, right? Our country was only founded one time, the Declaration of Independence and the Constitution. Maybe a few of you came today out of sheer curiosity just to pin down what this second finding was. And I'm going to reveal it to you now and just take the risk that most of you at least will still stay for the talk after I tell you about this second founding. Now, to be completely frank and honest, until a few months ago, I had never heard, even though I've been around the law, a long time, the phrase second founding. I'd never heard it before. But then I saw an article, this is American Bar Association Journal from just this past May, and there's actually a little one-page article in here, and the title is The Second Founding. And I saw that and thought, gee, what is that? The first sentence of the article is this: in the aftermath of the Civil War, the United States had a second founding, a period of reconstruction and reexamination of beliefs about freedom and equality under the law. And the article goes on to describe a new permanent exhibit at the National Constitution Center in Philadelphia, highlighting the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, which were ratified in 1865, 1868, and 1870, respectively. And the reason these three amendments are called a second founding is that they propel the United States in a new trajectory with respect to racial justice. Now, I've since learned that this concept of a second founding is well known to constitutional law scholars, which, by the way, I don't purport to be a constitutional law scholar. A recent book, just very recently, 2019, by a Pulitzer Prize winner, Eric Foner, actually is entitled The Second Founding: How the Civil War and Reconstruction Remade the Constitution. So now that you know what a second founding is, I hope that my title is even more clear. I don't believe that either founding, that is the first founding or the second founding, the post-Civil War founding, was meant to separate religion from politics. And in making my argument, that is, I'm going to try to defend that thesis, I'm going to emphasize two men. One very familiar, Abraham Lincoln. I wish this were a little bigger, but I'll bring it out here as I want everybody to be able to see it. I'm also going to emphasize a second man who will remain unnamed. For now, this man. I'm trying to make sure you stay through this talk, right, by giving you little incentives for staying. So I'm going to begin with Lincoln, defending my argument that the first founding was not meant to separate religion from politics. But first I need to say just a little bit about constitutional interpretation, because of course Greenhouse and Gillibrand's argument is that the Establishment Clause makes it unconstitutional to mix religion and politics. Again, the language, Congress shall make no law respecting an establishment of religion. Well, what do those words mean? And of course, that presents the huge question in constitutional law of how do we approach constitutional interpretation. Well, Ernest Young, a Duke law professor, has written that currently contemporary constitutional theory, I'm quoting him now, is dominated by a debate between two different approaches. One is originalism, which holds that judges should interpret the Constitution in line with its original public meaning of its text at the time the constitutional provision in question was adopted. You look back to the founding, what was the public meaning of the text? In contrast to originalism, there's the second prevailing theory, living constitutionalism, which is that constitutional meaning should evolve over time. Well, in my view, originalism is by far the best approach. Two of the reasons I would cite were stated well by United States Fourth Circuit Judge J. Harvey Wilkinson, a good friend of my colleague Ann Massey. And I'm quoting Judge Wilkinson. Living constitutionalism is a complete inversion of democratic primacy and turns the Constitution's foremost premise of popular government on its head. Living constitutionalism, in other words, is anti-democratic, democratic rule. It also is paternalistic, Wilkinson says, premised on the belief that a very few of us know what is best for the very many, that is, the rest of us. Now, Chief Justice John Roberts recently, I think, made the same 2 points in a much less formal way. He was speaking at Belmont University College of Law just a few months ago, and he said this, that the framers believed that judges should make decisions based on the law and not on personal policy preferences. And then, again, quoting Chief Justice Roberts, the people who drafted the Constitution, most of whom risked their lives in the Revolution, and all of whom had undertaken great personal sacrifice, for what? To have the opportunity to govern themselves. That's why all of this was done. Robert says this, they would not have gotten in Constitution Hall and had this thought, hey, I've got an idea. Let's pick a handful of guys who aren't elected, who can't be replaced, and let's let them make all the important decisions for us. Robert says, no way that that's what the founders thought was going on. So let's now turn to the first founding. My basic position is that the founders never intended the Establishment Clause to separate religion from politics. Instead, they had two main things in mind. The first one was to prohibit the establishment of a national church, and the second was to prohibit any preference being accorded to any particular religious sect or denomination. Well, the First Amendment was ratified in 1791, and a conventional approach would be for me to look at the evidence from the early 1790s and try to make this argument that the founders never intended to separate religion from politics. But I'm going to take an unconventional approach and instead ask, what did Abraham Lincoln think about the founders and whether they intended to separate religion from politics? And the answer is a resounding no. That is, Lincoln never thought the founders intended to separate religion from politics, and I will attempt to demonstrate that by showing that Abraham Lincoln himself routinely mixed religion and politics with never a passing thought to the fact that the Establishment Clause might have prevented his doing so. First, I think it's important to show that Abraham Lincoln would have agreed with Judge Wilkinson and Chief Justice Roberts on constitutional interpretation. He was an originalist who believed the founders themselves were the best guide to constitutional interpretation, to what the Constitution means. So this photo here, I wish it were a little bigger. Can people see it? This photo was taken by Matthew Brady in New York City on a very important night in Lincoln's life, Monday, February 27th, 1860. Now, why was that so important? It's really amazing, this juxtaposition. So he's walking around New York and he goes into Matthew Brady's studio and they take this picture. That very night, the same night, February 27, 1860, Abraham Lincoln gives his address at Cooper Union that Abraham Lincoln scholar Harold Holzer says the address that made him president. And in the superb book by Holzer, with the great title for my purposes, Lincoln at Cooper Union, the speech that made him president, Holzer makes his case. Now, he gives tremendous credit to this Brady photograph, which he calls a masterpiece, and says it was the result of the most felicitous photo opportunity in American history. That, this picture is taken, and that night Lincoln gives the address. Holzer discusses the photo at great length, and again, I can't recommend this book too highly. I'll only point out a couple of things. You'll note it's not a close-up on Lincoln's face, right? He's standing and kind of more at a distance. That was done deliberately to de-emphasize the deep lines on Lincoln's leathery skin and his unsightly warts and moles. You'll also notice that his collar was pulled up high, and again, that was a deliberate step. We need to pull your collar up to hide his sinewy neck. His neck not too attractive, apparently. And maybe most obviously, you'll note that he is beardless. In February 1860, Lincoln was in fact beardless, but there's an irony here in that it was the widespread circulation of this beardless Brady image that actually in part led to his growing a beard. A little girl out in western New York, not far from Buffalo, sees a variation of the Brady image. Grace Bedell, and in October 1860, the 11-year-old writes to Lincoln and says, "I think you should grow a beard. You would look a lot better with a beard because your face is so thin." Within a month, again, she wrote him in October 1860, within a month of his election, which was November 6, 1860, within a month of his election, Lincoln grows a full beard, and that's the way we know him, okay? No beard at Cooper Union. All right, but why was the photo itself? And by the way, you may be thinking, how could this photo have been so important? It was circulated nationwide, as was the address itself. Why the photo, though? And again, I'm relying on Holzer for everything I'm saying here. He says it was image transfiguring. Beforehand, Lincoln's image was as a vulgar stump speaker and rustic comedian. The Brady photo made him look presidential, dignified, resolute, powerful. According to Holzer, Lincoln's compressed lips, and I'm quoting, gave him a determined look, unlike the passive and distracted expression he had worn in previous photographs. Also, he's frowning slightly. Holzer says that assured voters who had never seen or even heard of Abraham Lincoln that he was up to the challenges that lay ahead. So this photo. But important as it was, the photo itself would have done nothing apart from Lincoln's triumphant speech at Cooper Union that same night, the very same night as the photo. And again, quoting Holzer, Lincoln arrived in New York as an ambitious pretender. He returned to Illinois, it's about 3 weeks later, as an intriguing second Republican choice for the White House, deftly positioned to triumph at the convention if the front runner, who was New York Senator William Seward, if he stumbled, and of course he did, and we're talking about May 1860. So Cooper Union, February 1860, the convention in Chicago, May 1860, Lincoln was nominated for president. Well, how did he get to Cooper Union? He was invited to speak in a fall 1859 telegram. Will you speak in Mr. Beecher's church in Brooklyn? Now, that's a reference to Minister Henry Ward Beecher, who was one of the most famous orators of the age. And he was the pastor of an equally famous church, Plymouth Church in Brooklyn, which was the most famous anti-slavery church in America. It was called Grand Central Station on the Underground Railroad. And Beecher, that name may have a familiar ring. He came from a famous family. His sister was Harriet Beecher Stowe, who wrote, of course, Uncle Tom's Cabin. So out of the blue, Lincoln gets this telegram, come speak at Beecher's church. According to Holzer, he viewed the invitation as an opportunity of a lifetime, the chance to transform himself from just a regional phenomenon to a national figure. Now, on Monday night, February 27, 1860, he still had that opportunity, despite his shock in learning only 2 days before that he wasn't going to speak at Beecher's church in Brooklyn. But instead, nobody told him. They moved the talk to, quoting Holzer, the new Manhattan Auditorium opened in 1859, the Grand Hall of Cooper Union. So Lincoln comes to New York thinking he's going to speak in the church in Brooklyn. It actually dismayed him somewhat because he said, hey, I wrote this speech looking at a church audience. That's what I was invited. And now you're sending me, without telling me, to the great hall at Cooper Union. And apparently he did some quick revisions of some kind. Now, he took full advantage of his opportunity. Listen to this quote from Holzer. Never before or since in American history has a single speech so dramatically catapulted a candidate toward the White House. That's pretty amazing. One speech. All right, well, what made the Cooper Union address so impactful? It had 3 parts. Part 1 was an appeal to the founders, and you're going to be hearing about that. An appeal to the founders. Part 2, an address to the Southern people. And part 3, an address, a few words he said to my fellow Republicans. So let's begin with part 1, in which Lincoln invokes the founders. I contend that it's this section that proves that Lincoln was an originalist regarding constitutional interpretation. His goal was to convince his listeners that the founders believed that Congress had the power to ban slavery in the federal territories. That was Lincoln's purpose, to convince people of that. But it wasn't a typical crowd-pleasing anti-slavery speech. According to Holzer, Lincoln avoided rant and witty points. Instead, he offered a laboriously researched, studiously legalistic anti-slavery treatise. I see my colleague Brian Murchison in the audience. I think it was within a year ago, you came to me and said, have you read the Cooper Union speech, didn't you? And you said, it reads like a legal brief, right? The first third of that speech, you don't think you're listening to some like popular public speaker. He is writing a legal brief, a deep dive into the historical record. Now, why did he do this? Because the front runner for the presidency, Illinois Senator Stephen Douglas, I'm sure rued the day when a few months before, in talking about this very question, does Congress have the power to ban slavery in the federal territories, Douglas, of course, argued the opposite, that Congress didn't have the power, and he invoked the founders for his position. Our fathers, when they framed the government under which we lived, understood this question as well and even better than we do now. And Holzer writes that by referring to the founders, Douglas was trying to introduced the founders as expert witnesses on this question, right? Does Congress have the power to ban slavery in the territories? And Douglas says, yes, they do. And Lincoln says, all right, that's your position. I'm going to use the first third of my speech to cross-examine the Constitution's signers. How? By the history of a number, multiple votes in the early Congresses on the very question of can slavery be prohibited in the federal territories. And Lincoln endeavored to show that a number of the people who actually signed the Constitution later on voted to ban slavery in the federal territories. For example, in the Northwest Ordinance of 1787, which basically is talking about Ohio territory, it banned slavery in those territories. And Lincoln uses that as one example among many. And you're sort of plowing through this speech, and he just, speech, enactment after enactment, Lincoln is bringing up. And hey, here's another one, and here's another one. So why was he doing that? To prove that Douglas had misrepresented the founders. Douglas says the founders thought you can't ban slavery in the territories. Lincoln says, oh yeah, I'm going to prove to you that they said Congress has the power. But again, I've got a very learned audience here, and a number of you may be thinking this is a fatal flaw in Lincoln's position, because didn't the United States Supreme Court in 1857 Dred Scott decision say Congress has no power to ban slavery in the territories, and actually ruled unconstitutional the Missouri Compromise of 1820? Well, you've got a Supreme Court decision that says Congress doesn't have the power. Now, a lamentable case, of course, based on the Fifth Amendment Due Process Clause. No person shall be deprived of property without due process of law. And the court interpreted the Constitution, and again, I hate to say this, but I'm quoting the opinion, as treating slaves like, quote, ordinary articles of merchandise. From Dred Scott. The Constitution treats slaves as ordinary articles of merchandise. Well, to deprive a United States citizen of his property just because he takes it into a federal territory, again quoting the case, can hardly be dignified with the name due process of law. And by the way, for those of you who like living constitutionalism, the Dred Scott case is generally referred to as the very first decision of the United States Supreme Court that used living constitutionalism and to support the result that it comes up with. Well, what did Lincoln make of this? I mean, this decision was 3 years or so prior to his big speech, and he's arguing that Congress does have the power to ban slavery. Dred Scott did not bother Lincoln at all. In the second part of the Cooper Union Address, which he's addressing the Southern people, Lincoln anticipated that the Southerners would bring up Dred Scott and say, hey, the court just ruled that Congress has no power to ban slavery in the territories. And Lincoln made a number of arguments that I can't go into to try to diminish the significance of Dred Scott, but one of them was that it was quoting Holzer, a bitterly contested ruling issued by a divided court, much unlike the overwhelming endorsement of slavery restrictions sanctified by the founders. All right, so let's pause and take stock. What's been demonstrated so far? First, that Lincoln was an originalist, and this surprising fact, he accorded more authority to what the founders had done about slavery than to a very recent Supreme Court decision that said Congress lacked the authority to ban slavery in the territories. Lincoln looked way back earlier in the nation's history, beyond and earlier than the Dred Scott decision, and said, hey, the founders show that that is simply untrue. So I now need to show that in opposing slavery's extension, Abraham Lincoln mixed religion and politics without worrying about the Establishment Clause. In the third part of the speech, the Cooper Union Address, Lincoln characterizes it as a few words to Republicans. And he basically says, how can we get along with these Southerners? I mean, what will satisfy them? The only thing will satisfy them, Lincoln said, is to cease calling slavery wrong and start calling it right. That's the only thing the Southerners will accept. But given, Lincoln said, Republicans' belief that slavery was wrong, and given their moral, social, and political responsibilities, could they allow it to spread into the territories? And the crowd shouted the obvious answer, no, never. And Lincoln ended the speech with his stirring and now famous peroration, let us have faith that right makes might. That right makes might. And in that faith, let us, to the end, dare to do our duty as we understand it. Raises the interesting question, though. Why did Lincoln think slavery was wrong? He provides a clue near the end of his speech when he criticizes the South for insisting that God approved of slavery and that the North needed to repent for attacking it. So, am I suggesting that Lincoln thought slavery was wrong because he thought it was wrong in the eyes of God? You know, is that the underpinning of Lincoln's anti-slavery view? Precisely. Lincoln many times made religiously based criticisms of slavery, openly religious anti-slavery arguments. He never even hinted that the Establishment Clause might be a barrier. Now, some of you may find this surprising because, after all, during the 1830s and 40s, the term most often used of Lincoln respecting his religious beliefs was infidel. I think he was commonly referred to as an infidel. For example, charges of religious infidelity plagued his run for Congress in 1846. He only had 1 2-year term in Congress. His opponent was the legendary Reverend Peter Cartwright, and I love this description, a rugged, sometimes violent, rifle-toting circuit rider. According to Carl Sandburg's biography, Lincoln attended a Cartwright prayer meeting during which the old evangelist addressed his audience. And the first thing he did was, everyone stand who wants to give their heart to God and go to heaven. A few people stood up. Then Cartwright said to the audience, everyone stand who doesn't want to go to hell. Everybody else stood up, except Lincoln, who stayed seated. Cartwright then challenged Lincoln. I observe, Mr. Lincoln, that you're the only one who didn't respond to either invitation. Where are you going? Lincoln's response, I'm going to Congress. Now, Lincoln outsmarted Cartwright on that occasion, and he actually won the election. But the fact is, Lincoln was likely an infidel at that stage in his life, at least according to Orthodox biblical teaching. But Lincoln's religious beliefs began to change dramatically in the late 1840s, and I thank my colleague Lucas for coming. He and I co-authored an article in 2012 which defends our position that by the end of his life, Lincoln believed in a personal sovereign God. Now, I'm not going to go into all that evidence here, but I want to turn to this. Do the facts support my assertion that Lincoln used religious arguments to criticize slavery? His first written statement regarding slavery was when he was an Illinois state representative in March 1837, and he simply said there that slavery was founded on both injustice and bad policy. When he was brought back into politics by the 1854 Kansas-Nebraska Act, Lincoln continued to criticize slavery, but he just talked about the monstrous evil of slavery itself. Now, these kinds of condemnations of slavery, of course, were not openly religious, but many others were. Lincoln argued, for example, that slavery violated Jesus' command that we treat others as we'd like to be treated. And he also argued repeatedly that slavery violated the biblical position on work, including in some famous venues. How about the second inaugural address in 1865, when Lincoln criticized the prayers of Southerners, saying this, it may seem strange that any men should dare to ask a just God's assistance in wringing their bread from the sweat of other men's faces. So again, the biblical concept of work Lincoln used. And in an 1858 speech, Lincoln relied on the Declaration and the notion of creator-endowed and inalienable rights. And I need to quote this. This was the founder's lofty and wise and noble understanding of the justice of the Creator to his creatures. Yes, gentlemen, to all his creatures, to the whole great family of man. And their enlightened belief, that is the founders, nothing stamped with the divine image and likeness was sent into the world to be trodden on and degraded and imbruted by its fellows. So to me, these religious arguments prove that a reference to Lincoln in a very good reference book called the Abraham Lincoln Encyclopedia by Mark Neely is inaccurate when it says that Lincoln did not mix religion and statesmanship. I think that is a palpably inaccurate statement. And his religious anti-slavery arguments to me show something significant about the first founding. The Cooper Union Address proves what? That Lincoln revered the founders and said we should look to the founders as to how to interpret the Constitution. And hey, that Supreme Court decision a few years ago, forget about that. Let's look to the founders. It's equally obvious, I contend, that Lincoln never thought that the Establishment Clause banned mixing religion and politics. Again, my speculation is that the idea never even crossed his mind. The first founding. The second founding. I've noticed some of you kind of surreptitiously looking at this picture throughout my talk. And I'm sure you noticed that I didn't give you his name at the start of the talk. Some of you may have been trying to figure out his identity. If you've got really good eyes, it's actually written upside down here, but you probably can't see it. Others, though, you may have been speculating as to his character just from his appearance. And maybe you came up with a profile like some of these contemporary reactions. This is from an 1863 New Hampshire newspaper. He's sharp in face and sharp all over. His face is deeply furrowed and indented, giving him the appearance of an austere, thoughtful man. His forehead is bold and intellectual. In 1860, the New York Times said this about him. His forehead is broad and mathematical. And on the whole, the expression of his face conveys the idea of a strong will inclined to extreme convictions and a temperament which is inclined to antagonize on every possible occasion with all and any who do not think the way he does. I love that description. Although I wonder, what's meant by a mathematical forehead and whether other academic disciplines can be used descriptively like that. For example, can there be a French literature forehead? And, what would that look like? Well, who is this mystery man? He is Republican Congressman John A. Bingham. Bingham is largely forgotten now, which is unfortunate given his many accomplishments. A recent biography, which I happen to have right here, describes him as one of the most important members ever of the United States House of Representatives. For one thing, he was a renowned orator. He was thought by his contemporaries to be one of the greatest public speakers of the age. This 1863 profile that I mentioned referred to Bingham's massive and manly arguments, enunciated in a sonorous, round, full, and powerful voice, flowing in spontaneous fullness and profusion from his tongue. A colleague described his voice as a steady, strong, on-sweeping wind, a powerful, steady, pealing blast. I really love that phrase, a powerful, steady, pealing blast. And I thought, that colleague must have gone to some law school and university faculty meetings. Now, Bingham exercised these oratorical skills not only on the House of Representatives floor, but on several other important, if not sensational, occasions. He made the chief prosecution argument against Lincoln's assassins, for example. He also made the final prosecution argument in the impeachment trial of Andrew Johnson before the United States Senate. So largely forgotten, but hey, he was prominent big time in his day. Now, but what about this second founding idea? The title of this biography is suggestive. American Founding Son, John Bingham and the Invention of the 14th Amendment. Now, the author, who's a law professor at Indiana, says flatly that Bingham wrote the most important sentence in the 14th Amendment, which is the second sentence of Section 1, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. But, you know, this is Bingham's biographer. Maybe he was biased in Bingham's favor. No, many other authorities refer to Bingham's indispensable role. Justice Hugo Black says that he can be called without exaggeration the Madison of the first section of the 14th Amendment. And this book, Foner's book, says that Section 1 originated with Bingham. More than any other individual, he was responsible for that section's wording, and he refers to him both as the 14th Amendment's key author and its chief author. Now, the National Constitution Center, though, uses even stronger language. This is in Philadelphia, and I looked at its website. It has on its website that you can listen to an August 2018 podcast entitled John Bingham, here it comes, Father of the 14th Amendment. All right, Bingham, huge in the history of the 14th Amendment. Now, but how does he support my view that the second founding does not support separating religion from politics? Well, in the same way that Lincoln supports a similar argument for the first founding, Bingham routinely made religious arguments against slavery and for the 14th Amendment. My contention is with no thought whatsoever to the Establishment Clause. In 1851, prior to his election to Congress, he made his anti-slavery beliefs clear in a speech to a college literary society. He asserted that the principle that informs our entire Constitution, and I'm quoting now, is the political equality of the human race, a full recognition of the truth that God has made of one blood all nations of men. Close quote. He calls slavery a system of oppression and horrid cruelty, a foul wrong, and the sum of human villainy. And in this same speech, he said, because slavery fettered the spirit that God made to be free, it is foreign alike to the spirit of our government and the spirit of our religion. All right, but how does that directly relate to the 14th Amendment? In 1866, on the campaign trail, he gave a speech that his biographer says was the most comprehensive explanation Bingham ever gave of what Section 1 of the 14th Amendment was intended to achieve. And what was its purpose? To embody what principle? Democratic government? No. The spirit of Christianity. The purpose of the 14th Amendment, according to Bingham, the father of the 14th Amendment, was to embody the spirit of Christianity. In another campaign speech, he said that Section 1 was the legal equivalent of the Golden Rule, asking his listeners, is it objected to by any Christian man to embody in your Constitution at least the simple Golden Rule that you learned at your mother's knee, whatsoever ye would that others would do unto you, do so even unto them. Now, my contention is pretty simple. Bingham's Christian explanation for the 14th Amendment itself proves that he did not believe that the Establishment Clause separates religion from politics. To make that argument is to support a logical impossibility. He wrote and championed the 14th Amendment to make American law conform to the Christian principle of equality before God. That's why he wrote the amendment. So he therefore obviously did not believe the Establishment Clause prevented mixing law and religion, because that's exactly what he was trying to do in the 14th Amendment. Now, it's very reassuring to me to learn that the 14th Amendment doesn't violate the Establishment Clause, but Bingham's perspective has a broader impact. On its face, the 14th Amendment prohibits 3 actions, but only by the states: abridging the privileges or immunities of United States citizens, denying due process of law, and denying equal protections of the law. Well, you'll notice that the Bill of Rights isn't mentioned there. Bingham, however, from the outset believed that the 14th Amendment made the entire Bill of Rights, including the Establishment Clause, applicable to the states. And he relied upon the Privileges or Immunities Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, the Supreme Court happened to reject that position in 1873, but that doesn't bother us. That's really doesn't matter. It's not relevant to my point now. My point is that Bingham, the father of the 14th Amendment, believed that the Establishment Clause applied to the states. And of course, in 1947, the court changed its mind and said, using another part of the 14th Amendment, said it does apply to the states. So how does this help us evaluate people like Linda Greenhouse and Kirsten Gillibrand, who invoked the Establishment Clause to criticize the governor of Alabama for saying that their restrictive abortion law reflects the belief in the sanctity of every human life? When you hear those kinds of criticisms, I ask you to remember John Bingham, the father of the 14th Amendment, who a long time, 80 years before the Supreme Court got around to it, Bingham wanted to apply the Establishment Clause to the states. And again, he had no idea, no thought whatsoever that the Establishment Clause prohibited mixing of religion and politics, given, again, his goal for the 14th Amendment was to embody the spirit of Christianity. Now, I miscalculated how long it would take me to give my remarks. I've got a lot more to say, but I'm actually going to stop it right here. What I was going to do is bring it more into the present, because some of you might be thinking, well, these are 2 old guys like a long time ago. Why do we care what they think? Let me just throw out one last thought for you. Did Martin Luther King Jr. violate the Establishment Clause in the Civil Rights Movement? It's irrefutable that Christianity permeated his campaign. For example, in his 1963 letter from Birmingham jail, he exhorted white moderates to be co-workers with God to achieve equal rights. And it's interesting, white ministers were kind of making the separation argument. The white minister argued, look, the gospel's got no concern with social issues. You know, the gospel's about getting to heaven when you die. It's got nothing to do with social issues like racial and economic injustice. How did King respond to that? In the letter from Birmingham jail, it's unbiblical to separate the sacred and the secular. He called for a return to the days when the Christian church did not merely reflect popular opinion, but was active in transforming society, as when, for example, it ended such ancient evils as infanticide. So, I think you've gotten the drift of my basic point. Brant gave me a hard deadline. I don't see it, but he told me he was going to have one of those air horns that he was going to pull out. It could be hidden in there. I don't want to subject anybody to that abuse, so I am going to stop here. I am willing to take a few questions if you have any, but I appreciate your... Yeah.
I am not an originalist, despite what my friend said.
Right.
But I think you're absolutely right. And I think that the Establishment Clause is about government support of churches. That I think anyone who speaks, politician or anyone else, is bound to speak in terms that are going to reflect that person's basic beliefs. I mean, that's what we want them to do, isn't it? And that's going to include religious beliefs if the person has them. So of course, yeah, and I disagree with Linda Greenhouse on this. I think the fact that a law happens to coincide with some people's religious viewpoint does not make the law illegitimate. I think what makes that abortion law illegitimate is the personal liberty protected by the 14th Amendment. But, you know, there are all kinds of differences of opinion on that too, and that's not
Right.
what you're concentrating
Well,
on.
thank you for that. And that reminds me, because Gillibrand, you know, when people talk about separation of church and state, they're really talking about the Establishment Clause. When they use that phrase, that's what they're talking about. Because in the 1947 Everson decision, where the court actually found the Establishment Clause applicable to the states, and again, Bingham wanted to do it way back from 1868. The Supreme Court got around to it in 1947. This kind of shorthand phrase that they used was separation of church and state, that's what the Establishment Clause is all about. And if you don't take anything else away from here today, take this away. That phrase came, as many of you I'm sure know, from an 1802 letter from Thomas Jefferson to the combination of Baptist churches in Danbury, Connecticut. The churches had written to Jefferson and basically said, "We're so glad you're our president because we're really fighting up here in Connecticut against the established Congregational Church. And they're, you know, giving us a hard time. And if we want to be exempted from like taxes, we've got to fill out some forms, and it's demeaning to us. You know, it's freedom of conscience. We should be able to believe what we want, and we're so glad you're president." So Lincoln writes back to them, and he says, "I consider our view with solemn reverence the provision of our Constitution," and he quotes the Establishment Clause, okay? And people like Greenhouse and Gillibrand read it or interpret separation of church and state because Jefferson goes on to say solemn reverence of the Establishment Clause, which establishes separation of church and state. Okay, so that phrase is in the letter. And Gillibrand and Greenhouse interpret it as if Jefferson's letter had gone on to say, and what I mean by separation of church and state is that no religious people should use their religious views to inform their public policy positions. Okay, but what does he actually go on to say? That religion is entirely a matter between a man and his God, and that no man needs to answer to any other for his faith or worship, and that the proper role of government is limited to restricting actions and not opinions. That is it. That is the explanation for the phrase separation of church and state by Jefferson, is to protect religious belief and faith and worship from government interference. I submit you cannot read that letter and come away with anything other than that interpretation. But people throw around the phrase separation of church and state and quote Jefferson as if he was saying you can't have your religious beliefs inform your public policy positions. That, in my view, is a distortion and even a criminal misinterpretation. Not that I wouldn't throw him in jail, right? But it is an outrageous misinterpretation of Jefferson. So thank you. Were you going to say something? Yeah.
I was just going to ask everybody to join me again in a round of applause to congratulate Sam Calhoun.